Say hi in the comment. Let me know where you're tuning in from. If this is your first time tuning in, definitely comment in the box. Tell me where you're tuning in from. Even if it's not your first time, share this video with your friends. Invite them to come on live. Are we live on YouTube yet? Let me see. If you are on YouTube and you can see me, comment in the box so that I know that you are live. Okay, so let me introduce myself. My name is Aisha Chidole. I'm an immigration lawyer. I represent clients all over the United States with their family immigration matter. We have a location here in Atlanta and another one in Orlando, Florida. But we take clients in all 50 states. I know we get this question all the time. You know, we accept clients in every state of the United States or internationally, as long as you want to immigrate to the United States through a family-based petition or a self-petition based on humanitarian reasons. For those of my friends and fam in Florida, I hope you guys are staying safe with this hurricane brewing and that you keep safe, you know. If you want to reach me here, you can call. I'm going to just type my number in here. Call 407-995. What's my number again? 407-995-6567. You know, I'm gonna just post it on here and pin it on Instagram. If you're on Facebook, you should be able to see it scrolling through the ticker. Same thing for those of you who are on Instagram. Okay. So just give me a second to type it because, as you guys know, I can't multitask. Type numbers while I am speaking. WhatsApp. Okay. And then pin it. And I have a good topic for you guys today. We're going to be talking about conditional green cards. 71. Okay, so there we go. Let's pin this. Okay, so it's pinned. My hair looks crazy today. Good morning, Gary. Thank you. Okay, so let's first start with what is a conditional green card? So a conditional green card is basically the type of green card that you get if you've only been married for under 2 years at the time of approval. Like, you know, as long as you get your green card through marriage, and at the time they say we've approved you, your marriage wedding anniversary has been less than 2 years, you will get a conditional green card. Essentially what that means is that in 2 years' time, you need to file for removal of conditions on those on the green card. If not, basically your green card, you know, you can lose your green card status and you can be put in deportation. And then, you know, of course, the way you remove the conditions on the green card is by you submitting a petition with your spouse, the same way that your spouse joins you in submitting a marriage-based petition, and then, you know, present it to USCIS. However, some things or sometimes, you know, things happen in marriage which makes a spouse not able to submit it with their other spouse. So that's really what we're talking about today. Good morning, Brenda, and Ray, and Nikea, and Schumer from New York. Okay, yeah. So so there are a few things that you can do if your spouse refuses to remove the conditions on the green card for you. So the first thing is, the first question is, are you guys going through a divorce? Are you guys divorced? If you guys are divorced, then you can remove your conditions without your spouse, as long as you can show that, one, your divorce has happened. So you can't, like, if you submit it because you're separated, saying, well, we're going to get a divorce, but we're separated, for instance, you get denied. You have to be divorced. So if you submitted it and you're kind of in the process of divorce, what typically happens is that USCIS will give you about 87 days to basically finalize your divorce. And if you're not able to finalize your divorce, they will deny you of your green card. And as you guys know, if they do deny you of removal of conditions of your green card, they will terminate your green card and you could be facing deportation. So that's one way. The second way is if you can show cruelty, extreme cruelty or battery like physical abuse and things like that in your marriage. With physical abuse, it's pretty self-explanatory. Even though there are some things that one would consider as physical abuse that doesn't necessarily involve hitting. Some examples of that are, i.e., you're in a marriage where even though you're a green card holder, let's say, and your spouse doesn't allow you to work, they don't provide food for you, they don't provide like feminine hygiene products. I'm just using this as an example. I'm not singling out men or women. I'm using this as an example. They don't want to add you to their health insurance, knowing that maybe let's say you're pregnant and they can add you, but they're like, oh, it's expensive to add you. So like that is something that would be considered physical abuse because they're basically looking at what is this person doing that's to the detriment of your health. So it's not necessarily that, someone is slapping you left, right, and center. It's just what they do that can affect you physically, that can be considered physical abuse. And then, of course, extreme cruelty is just the extreme nature of things that people do and cruel behavior, kicking you out of the house, making you, making you as a woman or a man sleep in your car for days because you have nowhere else to live, and just things like that. The standards when you're applying for removal of condition without your spouse are much higher than if you're applying for a valid petition because you don't have a green card. The reason that they do this is because they feel that, at this point you have a green card and that with a green card, there's so much more that you can do versus when you don't have a green card, where you don't have an SSN and you're worried about all that. So a lot of times they're going to want to see some sort of, real evidence, one, of a bona fide marriage. That's number one. Two, of, either psychological, abuse, or where you see a therapist, and stuff like that, or a police report showing that your spouse was physically abusive to you. But basically, the standards of evidence are higher. So it's really good to continue to keep those receipts of things that your spouse does to you when you have a conditional green card. Again, the standards are the same to prove that you have a bona fide marriage. Just like when you apply for a marriage-based green card and they ask you, show us proof of your marriage, show us proof your marriage is real. Like you can't come with those same types of proof when you're filing for conditional removal. Every proof that you submit has to be from after you got your green card. They don't want to see things from 2 years ago before they give you your green card. They want to see things from the date after they give you your green card till the day of the interview. So it's really important that you continue to accumulate stuff. The reason why is because they don't want people to be, today I get my green card and peace out, I'm out of this marriage. So it's really important to show, the bona fide nature of your marriage. So those are two options where you can remove the conditions in your green card without your spouse if they refuse to do it for you. If you can show extreme cruelty, you can show divorce. Another one is extreme hardship, like just showing extreme hardship, meaning, if you go back to your home country, the kind of hardship you experience, and stuff like that. So that is also another option that's available. And then, of course, the other one is, if God forbid your spouse passed away, but that's not really your spouse refusing to help you. That's really just, the fact that your spouse has passed away and then you're removing conditions based on that. So those are the options that you have. Let me answer some questions. Good morning, Tanya from Ghana. Have a blessed day as well. Good morning, OB and Nash. And God Child says, I have to send in my medical and I was arrested, but I was not charged or convicted and the case was dismissed and the seal should I submit the dismissal. So I can't give you legal advice without knowing what what your RFE says. So schedule a consultation and I'll be happy to go over with you. But generally, you should always let USCIS know when you've been arrested, even though it's been dismissed. Okay. Okay, good morning from Georgia, Blue Trillions, my beloved best lawyer in the world. It was great to meet you in person for the first time. Oh, hey, so that is who you are. Now I know who you are. Yes, it was so nice to meet you too yesterday. Um, Good morning, Cardi. Let me answer some of these questions in here. Okay, so my wife passed away after 2.5 years of marriage, and that was when I got my green card through VAWA. Um, When do you think I can apply for citizenship? 3 or 5 years? No, while she was alive, I didn't get any. I didn't get my green card after 2 interviews. They were just renewing my EAD. So we don't. So once if your green card is on the basis of VAWA, you don't wait 5 years, regardless of whether you're with your wife, whether your wife has passed away. You're eligible to apply for citizenship. As long as you meet all the other conditions. After having a green card for 3 years. Okay. This person asks, how long will it take to get a green card after an I-360 approval? For everyone, it's going to be different. So one USCIS division processes all VAWA petitions, right? So once they approve you for VAWA, then they start dispersing them to the local field offices who are going to adjudicate, meaning do the adjustment of status portion, which is the I-485 portion. And that timeline is depending on the availability of all the different field offices. For some field offices, it can take 6 months. For some field offices, it can take 4 months. For some field offices, it can take longer or shorter. So it's very different depending on the field office, but usually you should hear something. If maybe after like 6 to 7 months you've not heard anything, you can do an inquiry just to confirm that USCIS has moved your adjustment of status from the VAWA processing units to your local field office, especially if you are a client who had a pending 485 and requested like a continuance or an abeyance of your case. You definitely want to do that because sometimes they won't do the passing around that they need to do. Okay. Okay. Um, Carrie Ann says, what happens after you do biometrics for VAWA? After you do biometrics for VAWA, you basically just wait. I don't know what stage you are, whether you already got your prima facie determination letter, or whether you already got your, or you applied for a work permit and adjustment of status. If you did that, then that usually will come next, the work permit and the travel permit. If you didn't apply for that, the prima facie determination letter is what's going to come, and then you're just going to wait. Most VAWA cases, like I've said, take about 2 years to 2.5 years for approval. So if you do qualify for adjustment of status, you definitely want to do your adjustment of status at the same time, so you can put in a work permit and a travel permit application, because that way at least you can have your work permit and your travel permit application while your case is, pending. Shelly, Shelly, can you have a felony and apply for VAWA? Well, the answer depends. It really depends. One would have to see what the crime is, crime of moral turpitude, timeline spent in prison, how long ago was it? Because for VAWA, you have to show you have good moral character. You have to show you have good moral character in order to be successful with it. All right, I'm coming to you guys on YouTube. El Boogie says, good morning, counselor. I just wanted to say you look really fly. Thank you. That's one of my friends. um, um, okay, let's see. It's like Instagram. I think I need glasses. Like this Instagram texts are so small these days. If me and my girl have a child and neither of us have legal status, does my blank become a citizen? Yeah, that's actually a really good question. So your child by birthright becomes a US citizen. So even though you don't have status and your girlfriend doesn't have status, as long as that child was born in the United States, that child becomes a citizen. Okay? That's like me. My parents were not US citizens when I was born, and majority of my siblings, but we became citizens because we were born here. Um, Oh, boogie style. Okay, let me see. Let me answer some questions here. So Annie says, "Good morning, beloved lawyer. Good morning. Just filed an I-485 based on an approved vow for my three kids, 15, 14, and 12. Awesome. With I-131 and included I-693, but filed I-912 with proof of means tested receipt. I hope it goes through." Well, I hope it goes through as well. I mean, if it doesn't, just try and see how you can save for the filing fee and just pay the filing fee. But well done. Good job. Okay. Um, Joe Houston says the law making her the every day you step in front of the camera. Oh, thank you so much. Okay, let me answer more questions. Oyen says, "Good morning. I've been here for 4 years now and out of status. I got married in March. Can I file for travel parole while processing my green card?" Yes, Oyen. So, like, if you're already doing an adjustment of status and your case is pending, you definitely can file for a travel permit, which is also known as advanced parole. As far as when it's okay to use your advanced parole, I always say it really depends on what phase you are in the adjustment of status. For me personally, and what I advise to my own clients, if you've already had your interview and a decision has not been made, I do not recommend traveling outside the country, just in case that decision is not good. If it's before the interview has been scheduled, you don't have any removal proceedings, you've not had any issues with immigration or any kind of notice to appear in front of an immigration judge, by all means travel if you need to. And if you do travel, make sure you are traveling with all your documentation, because a lot of times if they call you for secondary inspection, they'll still let you in. But to reduce questioning, you can make sure you're taking like your green paper that shows your travel permit approval, your passport, and you want to make sure that all the things match, like your names match on them. And then you also want to make sure that you take a photocopy of everything else you take. Put the other one in a separate bag, just in case you go somewhere and they steal your stuff, you lose your luggage, so you can have something else. Okay. Um, okay. This person says, "What if my spouse wants to file for me and my daughter? My daughter is in Jamaica. Will it take much longer?" So I guess if you're here, it's going to be shorter, obviously, for you to process your paperwork. If you're shorter, any process that's done in America is always much shorter than any process that's done outside the country. Outside the country, it's all dependent on the consulate's busyness. Jamaica right now is one of the countries that, is delayed. There is a backlog, and I just tell people right now when you're doing consulate processing, just plan for 24 months. If it ends up being less than that, wonderful, but most likely it will be in that window. Um, um, Harvey says, "What does case on hold mean?" It means basically they're holding your case because either they're doing some sort of review or investigation on your case. Okay, let's see what else we have. Good morning, Pat. Cassine Francis says, "What's the next option for getting denied for filing when you were out of status and your wife is a green card holder?" Okay, so you mean that you got denied because you're out of status? Yeah, so the reason why you got denied is because your wife is a green card holder. In order for you to apply for adjustment of status, your spouse must be a US citizen if you're out of status, right? Your spouse must be a US citizen, otherwise you cannot adjust your status. If you've overstayed, the only way that you can adjust your status is if you've not overstayed and you're in a current status, whether that's in your B1, B2, F1, H-2B, whatever status, but you're in a legal status. So that's why. So for you, the best option would be for your spouse, as you said, your wife here, to become a U.S. citizen. Once she becomes a U.S. citizen, then she can file for you, and hopefully you wouldn't get denied. Rory said, just a follow-up question to the guy's question about having a child where both parents have no status. Is that grounds for the parents to adjust their status? So let's talk about this. So if you are a U.S. citizen, you can petition for your parents to get their green card. But whether or not you're going to do adjustment of status versus consular processing all depends on how your parents entered into the country. If your parents are in the United States, they have to have entered with a legal visa, and they have to be able to prove that they entered with a legal visa. In order for them to, even if they've overstayed their time and they become out of status, but they have to prove that they entered with a legal visa in order for you to apply for adjustment of status. And same question, same answer personally for us, where my sister and I filed for my parents. So my parents gave birth to us here. And, of course, we're citizens, and then we moved back to Nigeria when we were younger, came here, so, college, worked, and I filed for one parent, my sister filed for the other parent. Now my both parents are U.S. citizens because they got their green cards through us and then their citizenships when they were eligible for getting it. So yes, but they must have entered with inspection. Okay, I can take like 2 more questions. Mama Kelly says, is asking a question on asylum. Because I don't take asylum, I generally don't like to answer questions about it. Elboogie said, God bless you, you're walking in your purpose, saving lives. Thank you so much, I appreciate that. Bizo says, good morning, do they waive interviews these days? Well, it depends. It depends on what kind of petition that you have. A lot of times with joint filings, they will waive the interview. They will waive the interview if you have a lot of evidence to show that your marriage was bona fide for when you're filing for removal of conditions. So, and I'm specifically speaking about removal of conditions. So removal of conditions, they will generally waive the interview if there's a lot of evidence that shows that you had a bona fide marriage. Whether you're filing with your spouse or whether you're filing based on removal because your spouse refused to file with you because they've been extremely abusive or because of a divorce, as long as you have solid evidence to show that. And even if they do call you for an interview, I don't want that to be a source of panic, because some officers will still call you because they'll be like, well, I still want to hear the story, So it absolutely does not mean anything about your case or that your case is going to deny, but some people just want you to explain, why you feel that your spouse did this to you or whatever, so it's not a big deal. Another area that we see that we could see a waiver of interviews, like mother and child, because it's easier to prove genetically, like if a mother or a child when they're petitioning for each other. Not the same for fathers, especially if the father did not legitimate the child before they reached a certain age. Generally, in marriage-based cases, I would say 99% of marriage-based cases gets an interview of some sort. There's always a needle in a haystack where they've been married for 100 years and like have all these children and all this property and all these things to show that they, have a real marriage, that you might. But, in my own personal life and practice, I have never seen a marriage-based interview waived. But that being said, I do know that some colleagues have seen, like, maybe it's like a unicorn, like maybe 1 in 100 or 200 or 300 attorneys might have seen like one, waived, and it's usually for this reason. Okay, so I'll take this last question. Laura Bass says, so what happens if you file an I-751 jointly with your spouse and then you go through a divorce afterwards? So if that happens, then you need to amend your application. you need to amend your application, especially because you don't want them to approve you on the basis of you filing jointly, and then come citizenship, they'll say, well, how come you never let us know that you were divorced? So you just need to amend your application with a divorce decree. Okay, guys, I hope this video was helpful. We'd love for you guys to share it with your friends, your family members on Facebook, YouTube, Instagram. I'm not going to commit to a date or time, but I'm going to try and come on live a few more times during the week, like Tuesdays, Thursdays. I mean Tuesdays, Wednesdays, Mondays, or whatever as well. So just make sure you hit the notification button so that if I go live, you find out. But I don't want to give a date yet because I need to know that I'm able to commit to it. All right, guys, I hope you all have a wonderful week. And I will be back on live tomorrow morning at 10 o'clock. So tune in. All right, bye.